I actually bought a laptop before. Got it. I bought my laptop before I joined my diploma, and
Yeah.
it just died. It just died after my diploma. I have no idea why. It was only fine for about a year,
Uh,
and I should probably look into that.
yeah.
But yeah, so the I think the sign up for this is 120.
Oh,
Um,
goodness.
we usually like the last couple that they've had about 90, 80 to
Yeah,
92.
that's what I thought.
So we'll see how it kind of goes here because
Yeah.
I think we'd cut it off at 100
Mhm.
and it went to 100 quite quickly. So then we had to extend it.
Yeah.
Because obviously a lot of people that are in litigation, this is like invaluable for them. So
Yeah, well, I suspect this is one of the less exciting topics in the series.
I imagine because it's the less exciting one, as you put it, that you'll probably have a lot more people in attendance because the
Yeah.
last time I did litigation was like uh, my first C in my
Uh-huh.
traineeship. So that was quite some time ago, and
Yeah.
I remember coming across Rule 22 note, and I was like, I have no idea what this is about. It just couldn't like.
Yeah.
So I imagine there's a lot of people in that kind of area as
Yeah.
well. Lots of trainees and
Mhm.
NQs.
Yeah. No, I agree. I think it's really, yeah, I think it's a really good series, really good idea to run it. I mean, I think, yeah, exactly what you're describing kind of happened to me. That I did litigation as my first seat and then qualified into litigation and hadn't seen like a proof or a debate for like years. So I think running something like this is quite a good idea because pharmacists are like, have they asked you to all just go out and do it? What are you
Yeah,
complaining about? And it's
yeah.
actually quite difficult.
I know. Go read all the sheriff court rules and all this and that, and
Yeah,
then
it's like, well, we don't really
you can
tell you
figure
what
it
to
out.
do.
Yeah, no, I think so. I think that's why we've had such a large uptake with people
Mhm.
actually signing up. If I had this when I was in my litigation seat, it would have been amazing. I can tell you that
Yeah.
for. So yeah. When do you actually call to the bar?
June, so end of June.
Oh, really soon.
So yeah, in the home straight now, thankfully. Um,
I'm going to change my introduction then to end of June because I said later on in the year.
yeah, this is the kind of fun bit because all the exams are passed and we have quite a lot of classroom based stuff and all that's done as well now. So this is the kind of
Wow.
skivey bit, thankfully.
So you're just waiting at the moment for June, and then that's you. That must be amazing. I know it's quite difficult, the whole process. So
Yeah, it's quite a tiring process. Yeah.
yeah, I couldn't. I don't think I'd be able to.
Oh, I'm sure you would.
As you would imagine, we've got so many different advocates on the inquiry,
Yeah.
literally from all. I think the majority of them are on our inquiry, which is the Shape of Value public inquiry.
Yeah.
And they're also spread across the child abuse one. And yeah, I
Mm.
just feel like it's kind of the first time I imagine that people are having a lot of interactions with advocates from those law firms that are on the inquiry because we have so
Yeah.
many first time in Scotland. So
Yeah, exactly. I mean, it's just by sheer chance, it's kind of turned out to be quite a good time for us all to call actually, because there's just so many advocates are off doing these inquiries and things. They've had to kind
yeah,
of drop all their normal practice, so the bar is just overwhelmed with work at the moment, which is good.
is it quite a lot of you that are currently deviling?
11 this year, which is kind of average because last year I think it was 28, 25, 28, which is a huge number, the most they'd had since the 90s.
Okay,
Um,
that's not bad
so
then.
only 11, which is a bit more manageable for things.
Yeah, okay,
Yeah.
fair enough. I will just let everyone in and then we'll start in a second.
Sure. And I'll just stop screen sharing as soon as I'm finished. Right now, does that make sense? I'm maybe going to stop screen sharing for if there's any questions at the end.
Yes, of course, that's fine. Hi everyone, I am just waiting for a few more people to turn up and then we'll start. All right, we'll go ahead and make a start. Good afternoon, everyone. Welcome to the 5th session in the Scottish Young Lawyers Association Precognition to Proof series. My name is Brian Ellis Scott, and I'm an assistant solicitor to the Sheikh Bayou Public Inquiry. I'm also the secretary of the Scottish Young Lawyers Association. This afternoon's session is titled the Rule 22 Note, and it will be delivered by Ross Mitchell. Ross is a devil at faculty of advocate with a view of calling as an advocate at the Scottish Bar in June this year. Ross was also a solicitor advocate within the litigation department at Brodie's, where he specialised in commercial litigation, including contractual disputes and cases involving professional liability. Ross also regularly appeared in the court session and the Sheriff Court, and he's a tutor at the University of Edinburgh. So Ross is very much well placed to deliver the session today. Before we start, could I kindly ask everyone to take their cameras off, as well as their mic? If you have any questions, feel free to pop them into the chat box and we'll address these at the end. And finally, this session, like the ones before, will be recorded and it's currently being recorded as we speak. Finally, I just want to say thank you to Frazier Wright Associates for sponsoring our Zoom platform. So I'm going to pass over to Ross.
Great, thanks very much for the introduction, Brianella. Thank you for joining us this afternoon, everyone, for this particularly exciting topic in the series. Brianella and I were chatting before we started, and just remarking on how quite often, if, for example, someone does a litigation seat, as I did at the start of my traineeship, by the time it comes to actually qualifying or practicing, it can be years since you've seen something like a Rule 22 note or have to know what to say in a debate or a proof. So I think this series that the SYLA are running is really invaluable, and I wish I'd had it when I was qualifying as a solicitor. So what I'm going to talk about this afternoon is the Rule 22 note. We're going to cover how to prepare one, some suggestions for making best use of them in the context of an action, and how to respond to them. When I was preparing for this talk, something that really stood out to me actually is there's not a great deal of commentary and authority on Rule 22 notes. There's not a lot of case law saying how they should be used. There's not, for example, detailed practice notes on how they should be structured at all. So really what I'm going to be talking to today is drawing as much on my own experience as anything else, which I think can sometimes be useful in these situations. So, starting off, the purpose of a Rule 22 notes. They're often one of these documents that you hear people talking about, but until you've actually seen one and had to use one, it's difficult to picture where they fit in. But Rule 22 notes are strategically important documents for both pursuers and defenders in an ordinary cause action. And it's important to say from the outset that although they can sometimes take place, generally debates are not a feature of simple procedure or, for example, summary applications, etc. They're things in the Sheriff Court that take place in the context of an ordinary cause action. So ultimately, the point of a Rule 22 note is where you want to insist upon one of your preliminary pleas. That's really what it boils down to. So, for example, the defender's averments being irrelevant and separately lacking in specification, they shouldn't be remitted to probation. Separatum decree de plano should be pronounced. That's your kind of typical catch-all preliminary plea that you will get, which will cover irrelevancy and specification. Of course, you need to remember, if you haven't included a preliminary plea in your adjusted pleadings during the adjustment phase, then you can't lodge a Rule 22 note because there's nothing to insist upon. So really the thinking of going towards using a Rule 22 note starts before you can even think about drafting one. It has to be reflected in your pleadings, and which is why I would say, as a matter of good practice, when you're in an adjustment phase, I would always just include a preliminary plea anyway for the defender or the pursuer as your first one, a general irrelevancy or specification preliminary plea. And if you don't insist upon it, you can just drop it. But it's better, as soon as you know that an action is either defended or you as a defender are lodging your written defences, just stick a preliminary plea in there, and it will give you the option to rely upon a Rule 22 note later on if you want to. So just by way of reminder, what do we mean when we're talking about preliminary pleas? So a preliminary plea is one which, unless it is adequately responded to, will normally lead to the disposal of the action without any kind of evidential hearing into the merits of the disputes which the action is intended to raise. And the only exception to that is where the preliminary plea is so bound up in the merits that a proof is necessary in order to work out what the facts are. So, for example, it's not always possible to determine if there is a relevant claim based upon a party's written case. Sometimes you just need to hear evidence, even if there's an attack on relevancy. Ultimately, if a preliminary plea for the defender is sustained, the action will be dismissed, where it is sustained for a pursuer, decree de plano is granted. So examples of the preliminary plea are on the slide here. The one that we'll all be most familiar with, I think, is relevancy in accordance with the requirements of the case Jameson against Jameson. And we'll go on to talk about that in a bit more detail, what we mean by that. Another very common example is specification, where averments are lacking in specification, and so they ought not be admitted to, we say, probation. We just mean proof by that. A preliminary plea is also one that the action should be sisted pending arbitration. So if the contract is governed by an arbitration clause, etc., and you insert that as a preliminary plea, that is a preliminary plea that can be insisted upon in a Rule 22 note. So ultimately, the purpose of a Rule 22 note is to allow you to argue those pleas, that there is some reason why the action should proceed to a debate, i.e. a hearing on the legal arguments only, either prior to or instead of a proof taking place. So sometimes that can be because the defence is entirely... Sorry? Brownell, can you still hear me? You can, okay. Okay, great. I got a pop-up thing asking me to unmute. Okay, I'll just assume everyone else still can then. So what I was saying is that, ultimately the purpose of your Rule 22 note is to allow you to argue those pleas. And so it can be to say that a defence is entirely irrelevant and the action and decree should be granted immediately. Or alternatively, you can kind of have a halfway position where you're saying some part of the claim or defence is irrelevant or lacking in specification, and you don't want the other side to be able to lead evidence about that specific part of their claim at proof. So there can be a real strategic benefit to arguing that part of a claim lacks specification, even if you know that a proof is still ultimately going to take place, because you can't have the other averments chucked out. You want to be able to restrict what is going to be argued about at proof because their written case lacks either relevancy or specification. Okay, so just a very brief reminder on some of the key rules. So funnily enough, a Rule 22 note is called that because it finds its basis in Rule 22 of the Ordinary Cause rules, which I've copied on the slide here, and I've highlighted a couple of the key points I think it's worth talking about briefly now. So the first point is that you need to lodge and intimate it at least 3 days before the options hearing. and you're going to know when the option hearing takes place. Once you lodge defences, obviously the court should send you your timetable out, so you'll know exactly when that date is going to be, and you want to make sure you lodge a Rule 22 note at least 3 days before that. And that means lodging it in process with the court, but also intimating a copy to the other side. 22 sub-rule 2 is quite an interesting one, and it's one that people sometimes forget about and can be caught out. If the options hearing is continued, as any of us that have done sheriff court work know is a pretty common occurrence, if you want to insist upon your preliminary pleas at the next options hearing and seek a debate, you need to re-lodge your Rule 22 note. You can't just rely on it being in process the first time round. And as I say, that's one that can quite commonly catch people out. Even if it's just a case of posting or emailing the exact same note again, you've still got to do it in advance of the next options hearing. Or alternatively, the sheriff can turn around to you and say, no, it's being dropped. I think arguably there's no discretion given to the sheriff on that rule. And that's spelled out in sub-rule 3, where it points out that if you don't comply with either 1 or 2, i.e. send it in advance of the first options hearing or the continued one, you're deemed to no longer be insisted on your preliminary plea, and it needs to be dropped from your pleadings. I've also highlighted Rule 4, because again, this is something that I've seen catch a lot of people out when it comes to debate. Any point that you want to argue at debate has to be foreshadowed in your Rule 22 note. So you have to have made the point in Rule 22 note. You can't just say, I want a debate on relevancy and insert argument A, but then when it comes to it, you think about argument B 3 weeks before the debate. You can't argue that unless it's fairly set out in your Rule 22 note. The only way you can get around that is at the debate under 22 sub-rule 4, on cause shown, you can seek to raise additional matters. And the cause shown test is a high one. It should be a high one. So you're really, I think, going to struggle to introduce new points at debate that aren't in your Rule 22 notes. And the way that you can get around that is to lodge a second Rule 22 note, which we're going to talk about in some of the subsequent slides. Okay, so how do you know when to lodge a Rule 22 note? And I think this probably is the hardest part of the talk and the concept of Rule 22 notes, knowing when to produce one. So your starting point obviously comes from considering the written pleadings. Now, generally you should do this when the record closes. It may well be that during the adjustment phase, you're spotting issues with the other side's pleadings that come up either in relation to specification or relevancy, and they get addressed in an adjustment phase. So I would say the best time to think about knowing whether this is a Rule 22 note might be needed is at the close of the adjustment period. But what I would say is that if, as adjustment is going on, you have a concern about particularly specification during the adjustment phase, it can sometimes be helpful to place a call in your pleadings asking for the other side to specifically aver something. So if you think something is missing a key date, a key time, a key contractual document, you can place a call on them to address that in their pleadings. So there's different reasons for doing that and sometimes for not doing it. When it comes to a debate, though, it can be much more convincing to the court if you are in a position to say, well, look, I place a call on them to aver this in their pleadings and they still haven't responded to it. And it's much easier to convince a court at debate to have less sympathy with their position if you can say, we've given them plenty of warning to put this in, and they've not been able to. And that can be a useful tactic. The flip side of that, though, is, and this shows why it's always context specific, is sometimes you want to keep your powder dry. And if there's a glaring hole in somebody's case, you don't want to necessarily always help them out by placing a call in the pleadings that they can fix. And sometimes there's a real tactical advantage to either to not pointing out and either forcing them to lodge a minute of amendment and you get the expense of that, or to take it to debates and hit them with it at the first time when you lodge your Rule 22 note. So it's always context specific. I think sometimes if you think that they can't answer a point, if you know that they don't know, placing a call can be quite useful. Generally, though, when you're thinking about preparing a Rule 22 note, I would say think about them in terms of relevancy and specification separately. I would read the other side's pleadings first from the perspective of relevancy and then separately look at it from the perspective of specification, because it can become very easy for the two to become confused, and you want to avoid that. So what do we mean by relevancy? And this will just be by way of reminder for a lot of us. So the formulation of relevance that I'd mentioned from the Jameson case is that an action will not be dismissed as irrelevant unless, even if the pursuer proves all his averments, it must necessarily fail. So people often talk about it as being the so what test, i.e., if everything the other party avers is true, do they still fail to meet the relevant standards for that basis in law? I.e., we don't need to hear any evidence on this point. And Miller on civil pleadings in Scotland has quite a good formulation of it as well, which I'll just read out. What the opposite party says may be true or it may not, but even if it be assumed that it is all true, nevertheless, he cannot prevail against me, either because an essential fact is unrepresented in his averments, or because the fact he avers would not, even if proved, justify the application of the legal principles to which he appeals. So I know there's going to be a session on debates in this anyway, so I won't get into that in too much detail, but the important thing to remember when you're thinking, should I prepare a Rule 22 note on relevancy, is that at debate, all of the other side's averments will be treated as pro verite, which means true. So you can't go into a debate and challenge a factual averment that they make if you're attacking relevancy. You have to assume that everything they say is true, but you're saying, well, so what? Even if they prove all those facts, they still don't have a relevant case in law. One that you see quite commonly in reported contract cases, for example, just to give an example of this, is in relation to implied terms. Quite a lot of cases fall down on relevancy and implied terms in contract law, because you get people who and businesses that have contracts, but there's a gap missing and they want to be able to rely on an implied term. And so they just aver it was an implied term of the contract that you would do X, Y, or Z. But if you read the case law on implied terms, there's quite a strict test in terms of business efficacy or being necessary for the contract to function as a whole before you can imply it. It's quite a high bar. And unless you include the averments in your initial writ saying why it meets those tests, your claim is irrelevant. So that's quite a common one that you see thrown out on relevancy. So the way to approach relevancy is you've got to really understand and research the legal base of your opponent's case. So once you've got their writ, look at what they're saying. I would always start with textbooks. Go to the textbooks and see, what does the law say are the essential ingredients of this claim, and does their case meet it? But you can still attack relevancy even without looking at textbooks or case law, because sometimes you'll have gaps in a case which make it irrelevant. It might be internally inconsistent in the averments it makes. It might be that there's a glaring gap in their case. So, for example, if somebody is suing for damages and you can see a break in the chain of their averments in terms of how your client's breach of duty then led to the loss they're suing for. You know, if there's a gap in that chain, that would be a relevancy point that you can take. The other category is obviously specification, and so I'll just cover what we mean by that briefly. So one of the functions of written pleadings in Scotland is obviously to give your opponent and the court sufficient knowledge of what your case is going to be. And what McPhail's share of court practice says, which I think is quite a nice way of summarising it, is that a party's averments in their condescendence or their answers must specify sufficient facts to allow the party to lead all the evidence desired to be led at the inquiry, and to give the opponent fair notice of what the party hopes to establish in fact, and they must present, together with the pleas in law, a relevant claim or defence. So, of course, in Scotland, we plead facts and not evidence, so you have to plead all of the facts that you want to set out. But even if, once you've set out all of your facts, you fail to give your opponent fair notice, which is the kind of general test we're applying here, your case will be lacking in specification and you won't be permitted to go to an evidential hearing where you're not giving them fair notice of the facts that you intend to prove against them. So that's obviously quite a general test, and so it's difficult to talk about it too much in the abstract, but it will depend on the particular circumstances of each case as to whether there is sufficient specification or not. So some of the key factors that you want to think about is enough specification has to be given to enable the other party to identify exactly what's being alleged against them and to prepare their case. So any material dates, time, places which ought to be reasonably known should be specified. And if once you've got the written pleadings, you just think, I don't have enough to go here and investigate, or they've not averred sufficient facts that will allow them to lead evidence to prove their case, you can prepare Rule 22 note on the basis that it's lacking in specification. Okay, so thinking now about preparing the Rule 22 note. Generally, I would say that Rule 22 notes should be quite short documents. You don't want to be seeing something going on for pages and pages. Really, what you want it to be is a short document giving headline points so the court can understand where your argument is going to go. You know, they don't need to understand the full detail of it. There's opportunities for that to come. It's really about headline points, because what you need to remember is that if your Rule 22 note leads to a debate being granted, you're probably going to get the opportunity to lodge written submissions in due course, and you're almost certainly going to be able to make oral submissions down the line, either virtually or as increasingly the case now, at least in the court session, in person for debates. So don't make it too long. I would say generally you're looking at sort of 3 to 4 page document at the max, unless your case particularly needs it. And quite commonly, I would see sort of 1 or 2 pages in practice, and I think that really is sufficient. So the note should be very clear and concise, and I would say using numbered paragraphs. This is a kind of pedantic point, but you should call it the note of the basis of preliminary plea. Don't call it a Rule 22 note, because although it finds its basis in Rule 22, there's nothing called a Rule 22 note in black letter law in Scotland. It's a note of the basis of your preliminary pleas. Your propositions of law should be very brief, 1 or 2 sentences if you're making a proposition of law in relation to relevancy. There's sort of mixed views on this, but I think it's quite helpful to cite authority on the point. There was certainly a view that this shouldn't be done sort of 10 years ago, I think. But increasingly we're seeing in sort of equivalent notes in the Court of Session a case given to support a proposition, and certainly it's something that I didn't practice in Rule 22 notes. And I think it's a useful thing to do because it gives the court confidence that you're not just making up a point on relevance. There's some kind of basis to your argument here. But really, I would only cite one authority for each proposition that you're making. Make sure you give the full case citation. And if there's a particular paragraph or a couple of paragraphs, give the paragraph number as well. Don't copy and paste the quote of the case into the Rule 22 note. Just articulate the proposition in your own words and then give the case next to it as well. What you should also do is make it very clear when you're drafting your Rule 22 note, when you're talking about specification and when you're talking about relevancy. I think a good way to organise your note would be to deal with relevancy in the first half and specification in the second half. That's personal preference. There's also no harm in using subheadings that can sometimes make it easier to follow. So you could have, for example, your first half of your Rule 22 note is subheaded issues with relevancy, and the second point is a subheading could be issues with specification. Just make it very clear what you're talking about. When it comes to attacking specification, I also think it's really good to quote the averment that you're saying is lacking in specification in full. And I say this from experience because if you're saying that certain averments should be omitted and not permitted to proof, you sometimes find at the end of the debate, if you've not quoted in your Rule 22 note what it is that you are attacking, i.e. sentence by sentence specifically, the sheriff will say, well, look, I agree with you. They haven't made out that case, that those averments shouldn't be admitted to probation, but what sentences is it that I should be deleting, please? And ultimately, you're always trying to make the judge's job as easy as possible for them. And so if you've quoted the averments that you say are lacking in specification, they can just look at your note and go, well, I agreed with them on that point, so I'm taking out this sentence, and this sentence. So I would always do that. And then finally, as I say, don't make it a long document, sort of 2 to 4 pages, and don't confuse it with a note of argument, which is a much longer document. In terms of styles, I've thought about in the slide showing one here, but I didn't think that would be particularly helpful because they're always so different. But there are quite useful sources for Rule 22 notes out there. Green's Litigation Styles, which is on Westlaw, has a list of Rule 22 notes, which are all pretty good. And if your firm has a decent library, you'll probably have Bennett's Sheriff Court Styles, and there'll be Rule 22 notes in there. What I tend to do in practice was just search my firm's DMS and come across styles to use them as a starting point. Styles can be really helpful as long as you use them just to kind of get the general structure and see how to phrase things. And if you do a search for Rule 22 notes on your firm's DMS, you'll see how different they all are. And that's because there are no real hard and fast rules on how they should be structured. Ultimately, what you're trying to do is create a persuasive document, which is easy to follow. And a question that I remember getting asked a lot is, should you sign one? I think probably the answer is yes. So I put an in respect whereof and sign a Rule 22 note data as well. So I thought I'd say just a few words on the flip side of this. What happens if you get a Rule 22 note? Panic is most people's immediate reaction if they weren't expecting it, because you think, oh no, I'm going to have to defend something at debate that I didn't really want to. And it's worth taking a moment to be calm and realize that there's tactical reasons for people lodging a Rule 22 note, and there are ways for dealing with it. But it can be difficult not to panic at first, because it's often a reflection of your own written pleadings, and you think, oh, what have I missed here? So start off by considering, the case that they are making. It may well be that you look at their Rule 22 note and you think, well, actually, they're just wrong on the legal points that they're making here. If they're citing cases, read the cases, see if there's a different slant that can be put on them, how they've been treated by subsequent courts, are there contradicting authorities elsewhere, read the textbooks, It may simply be that they're wrong on the point of law that they make, or at least there's a persuasive case that can be made on the other side that a different interpretation should be taken. And the thing to remember is that, sometimes cases get struck out on relevancy, not because of failures in our written pleadings in the way that we drafted the case, but because our clients' cases are just irrelevant. Sometimes you will just read the authorities and say to your client, look, this case is skirting the boundaries of relevancy, and we've said as much as we can in our written pleadings to make out a relevant case, and we will just have to debate it and argue that it falls within the law. But it may be that you think that they have a point in the Rule 22 note, and that you think that there are things that you can do to address it. If that is the case, you're going to have to prepare a minute of amendment, because of course the record is closed by this stage. What I would say is, don't be afraid to amend if you have something that you can say that will correct the points. There's often a fear around amending because A, your client will incur the expense of answering it, but B, there can sometimes be a sort of phobia around amending because you think, well, this is something that we should have included in the adjustment phase. But the reality is sometimes you just need to do it, and it's not always possible to plead a perfect case in a vacuum without understanding the attacks the other side is going to make on you. So always do it as soon as possible. You don't want the other side to incur more expenses that will form part of that by them saying, oh, well, we prepared preparation on the back of the Rule 22 note, or we prepared for the options hearing on the basis that we were going to be asking for a debate. Just bite the bullet and intimate your minute of amendment as early as possible, because it's also more likely to be allowed by the courts if you take that kind of approach. And so this is our last point before questions. So you've either prepared and lodged your Rule 22 note, or you received one. So now, what role does it play once you've done that and you've produced it? So the first point that there's going to be discussion about your Rule 22 note is at the options hearing. And if you want to have a debate on the back of your Rule 22 note, you're ultimately going to have to convince the court to give you that at the options hearing, and the Rule 22 note forms the basis of you asking for that. So it may be that in your Rule 22 note, you have what we often talk about as being a knockout blow, that if you're successful on your points in the Rule 22 note, the case ends there. And if that is the ultimate outcome of your Rule 22 note, if successful, make that point clear to the sheriff. Just say, look, this Rule 22 note contains, points that will result in decreed plano, or the action being dismissed. Because although procedure at this stage is really a discretionary one for the sheriff, they can go either way, and you can't appeal it without their permission. You're much more likely to get a debate on a point if you can say to the sheriff, this is going to resolve the issue now. You have a slightly harder job if your Rule 22 note is implicitly accepting there's still going to have to be a proof, even if every point in your Rule 22 note is upheld. So that is what we see if you're only striking some averments out, either on the basis of relevancy or specification. So essentially, you've gone through their pleadings and you think, we should just strip out all of these averments, because they're nothing to do with the case or they're lacking in specification. But you can still see if, and a good tip of practice would be mark up on your own record, strike them all out, the ones that you're going to attack, and then look at their case and go, well, there's still something there that the evidence will need to be heard on. In that kind of case, have a think about the effect of your notes. Are you still able to go along to the options hearing to the sheriff and say, well, look, I accept that a debate will not resolve this action, but it will shorten a proof, for example. So if you look at what you're proposing to strike out, can you say, it will cut down the need for certain types of witnesses, or I think this will take a 2-day proof to a 1-day proof? That's the kind of things that you can say to justify something going to debate, even if you accept it's not going to resolve the matter there and then. And hopefully you'll get a debate. You generally will. It's pretty unusual, I would say, if a party's Rule 22 note that they're insisting on it and options hearing for a sheriff not to give it. You've got to come across a particularly grumpy sheriff one day for that to happen, I think. So you're then looking at a debate. And as I'd mentioned in the slide about the rules, any arguments that you want to make at debate have to be contained within your Rule 22 note. So you can't include a new argument or a new attack on relevancy that isn't mentioned in your Rule 22 note. So the way that you get around that is not to just say the pleadings are irrelevant and not specify them, because you're not going to get a debate on that. But what you can do, and I saw this commonly done in practice, even though it's not explicitly discussed in the rules, is lodge a subsequent Rule 22 note. There's no prohibition in the rules on you, after a debate is allowed, lodging another Rule 22 note and making it clear to the court and to the other side that these are points you're going to be relying upon at debate. And I have to say, I never had any pushback on that approach. It's a much better way of doing it than seeking leave at a debate to include new grounds, where, as you know, you're going to have to show cause. So I would just lodge a subsequent Rule 22 note, and generally you'll find people are okay with that, as long as you do it sooner rather than later. And finally, Rule 22 notes, although this is often forgotten about, they can technically form a rule of proof sometimes. So if you are sustaining a preliminary plea and you're going to proof, technically your Rule 22 notes is relevant, because you're going to have to lodge it in order to insist upon your preliminary plea at the end of evidence. And just to be clear, when that will arise is if you're unable to sustain a preliminary plea at debate alone, you accept that there has to be some evidence because they pled a relevant case. But when it comes to that evidence actually being heard at proof, there are gaps which make their claim irrelevant. You're still going to be asking the court to sustain a preliminary plea at the end of proof. And so in theory, your Rule 22 note has allowed you to do that, to keep them in following the options hearing. But the reality is they're totally forgotten about, because they're completely overtaken by the evidence and the submissions. But I just make the point, which is that even if you want to go to proof and you want to keep your preliminary pleas in there, technically it's good practice just to lodge Rule 22 note anyway, I think. And that's it, thankfully, 39 minutes. So, Brian, I don't know if there are any questions that have come in at all. Maybe stop sharing my screen.
Yeah, no questions so far, but thank you, Ross, for that. That was incredibly helpful. I'm sure that the session has been invaluable to those that are attending as well. As Ross has asked, if anyone has any questions, if you can pop them into the chat. There's 83 people on the call, so I'm sure one of you might have a question for Ross. In the meantime, I do have a question for you, Ross. What are the most common pitfalls that would result in a Rule 22 note not kind of gaining traction or allowing the other side to easily pick holes in it?
It definitely specification. So, and actually, I'd put the phrase petty points of specification in my slides. I didn't talk about Ranel, but I think a common way that when you see Rule 22 notes being lodged that don't succeed, it's where somebody has just made a load of specification points. And what they're actually doing is they're not really saying that it lacks specification. They're just saying, you could have phrased it better, or you could have given us a bit more detail. There is a tendency to lodge Rule 22 notes attacking specification when, in reality, it's tactical, it's stalling if you're a defender. And as I say, you're basically just saying you could have phrased it better, or you could have given us more detail. But in reality, there is a relevant case there that should be allowed to go to proof. And particularly, it's a bigger thing in the court session just now, but it is a trend that we're seeing in the sheriff courts, which is that there's less reliance now being placed on the importance of written pleadings. Courts are generally more accepting of briefer pleadings than was the case, 20 years ago if you look at old records. So I would say if you're going in just on an attack of specification alone, it's got to be a pretty good one.
Perfect, thank you. That kind of leads us really well into the next question from Arthur A, who's asked, is it always better to be shorter in a Rule 22 note? And if this is the case, is it less likely to be picked up upon?
Yes, I would say it is always better to be shorter. So as I say, so take the example of an implied term of a contract, which is the one that I use in the slides. So I would say it's much better to just say the pursuer's case that there was an implied term is a relevant new sentence. In order to plead a relevant case in implied terms, a pursuer must set out why the contract doesn't work, or B, why it's important for business efficacy, and cite a case and leave it at that. The reason it's better to be shorter is, one, you're not tying your hands later on if you want to develop that point. Two, in reality, when it comes to preparing a Rule 22 note, it's early on in an action's life, so you don't want to spend a huge amount of time and clients' money on them. But three, if you think how busy sheriffs are in an options hearing and how much time they've got to prepare in advance, it's very little. So short headline points is really what's expected.
Perfect, thank you, Ross. That was really helpful again. Just waiting to see if you have any more questions. And thanks, Arthur, for popping that question through for Ross. I think your presentation was that well that no one has any questions for you, Ross.
Yeah, no problem. If anyone has any by now, we can always answer them afterwards, or you can message me on LinkedIn. That's no problem.
Yeah, of course. If you guys have any questions that you'd like to follow up on, please do send them into our email at mail@silo.co.uk, and we can follow up with Ross. So if no one else has any questions, I guess it's just for me to say thank you so much, Ross, just for joining us today for this session and for giving us your time as well and your expertise. I found it very helpful. And thank you to all of our attendees as well for joining and engaging with this event. I know it's your lunchtime, so really appreciate it. We have a number of these Precognition to Proof series sessions still to come over the next couple of months. The next one is options hearing, which is on Monday the 22nd of May, and thereafter Wednesday the 31st of May for motions. Same time, 1 p.m. So if you're looking to join us for those, just head over to our Eventbrite page and sign up for those. Thank you, everyone.
Great, thank you.
Thanks.
Thanks.
Thank you. Bye.
Bye.
Thanks. Bye.
Bye.
Thanks. Bye.